Good morning, everyone. We're having some tech issues today, so we're doing what we call tin can sound. We worked for about 5 minutes before we got online today to try to eliminate echoes with the microphone, and can't, so I'm just going through the computer. Welcome to Matroska from the Netherlands. That's our new one.
Yeah, what is this about? What is this about?
Well, anyhow, good morning, Mike. How are things down in North Carolina?
They're beautiful, man. They're beautiful. Spring is the best here. I spent probably an hour watering plants last night. You know what I mean?
Well, good for you.
It's not even a metaphor.
Yeah. Our weather is New England. I mean, it was 30 and wet last night. So, sitting with some friends and in a recliner.
30 and wet, is that a metaphor?
Yeah, I know. Sitting in a recliner and said, man, it's cold in here. And my friend's wife said, do you want an electric blanket? I said, that's the last thing I need is my friend to see me in an electric blanket in April. And he came walking in and I mentioned that. He said, yeah, I'd tease you forever. So, the weather is what the weather is. Lots to talk about today, if you're a regular listener, I was telling Mike beforehand, sometimes I can watch these events in these cases and public affairs and think I know what's going to happen next. I frankly have no idea in some of these cases. And it's unnerving. I wish I did. And what am I talking about? Let's first talk about Trump jury selection and what's going on in that case, in the hush money case, the Stormy Daniels case. Donald Trump faces 34 counts of falsifying business records to disclose, and by saying that hush money paid to Stormy Daniels was a legal expense rather than a campaign expense. Good luck with the jury on that. I can see jurors going one way or the other on that. I could actually can't they be both? And if they're both, is he necessarily guilty? And that may be an issue of first impression, meaning an issue that a court hasn't decided. But in any case, to get to the point of a verdict, you have to have jury. And in New York, like every other jurisdiction in the United States, if you have a right to a jury, that means you have to pick a jury. And so the court and counsel engage in jury selection. We've had 3 days of jury selection in New York thus far, and 12 jurors and one alternate have been selected. 7 women and 5 men, right now at least, will be the jury in the Trump case.
Hey, Norm, what are you charging over there? What device do you have?
Turning it off. That was my cell phone. 7 men and 5 women will be the jury in that case, should that jury hold. 1 alternate has been picked. They'll be looking for 5 more today. And I'm actually stunned by some of the decisions, at least as reported, about jurors selected in this case. One in particular. It's reported that one juror was a guest in one of the lawyers' homes 15 years earlier and was nonetheless picked to sit on the jury. It makes my head explode. I don't know how that's possible. The law, there's a broad public misunderstanding about jury selection. The public often believes that jurors are to be totally ignorant of the parties and the case or allegations in general, and therefore that is what a juror should be. And anybody who knows anything about a party or anything about the case should be excused from service. That's going to be that's not the standard. Now, when jurors were initially impaneled in medieval England, they picked from jurors or from the panel or from the community, people who knew the participants, and their knowledge of the participants in the community was to inform their verdict. That we're 180 degrees removed from that now. We don't expect jurors to be ignorant of the altogether ignorant of the parties and process, although that might be better. But we accept the fact that in some instances people know about the parties, and in some instances people know about the allegations because they're so high profile and because they've been publicized. Thus, in the Donald Trump case, it would be difficult to find a sentient, that is thinking juror in Manhattan who doesn't know about the guy. I mean, he's a larger than life presence on the New York scene for decades. He was a reality television show about his work that he did in New York and elsewhere. He's been president of the United States. He's now facing criminal charges in a number of jurisdictions. He's had a record-setting verdict against him, not a record-setting, but a large verdict against him in the E. Jean Carroll case. If you don't know about Donald Trump in New York, what are you paying attention to?
If you don't know, now you know.
Well, it's a serious question. When a psychiatric patient is being evaluated, somebody brought to the hospital, they want to see if they're oriented to space and time, oriented to place. And one of the questions they'll ask is, who's the current president of the United States? Well, he may not be the current president, but he gets more publicity in some people's view than the current president. And so you might be insane. If you say, I don't know, that's going to raise suspicions in a psychiatrist's mind about your competency. So to pick a competent juror in this case means you're going to pick somebody who knows something, presumably, about Donald Trump and knows something, presumably, about Donald Trump and his legal problems. So then the question becomes, what is the impact of that knowledge on the juror? And you see this often in ordinary jury selection in non-high profile cases. I once had a case involving the death of a police officer in Connecticut, a man named George Dingwall. My client was a drug addict involved in some thievery. Dingwall came to a house where my client was seen leaving with items in the house, and there was a high-speed chase down the highway. Dingwall lost control of his car and died, and my client was charged with felony murder. That is, causing the death of a person while fleeing from a felony. We argued that he didn't cause the death while fleeing from the felony, that Dingwall's driving, the icy road conditions, and other things did, and the fact that there were mismatched snow tires on the car in violation of standards set by Goodyear, and the jury acquitted on the felony murder charge, and perhaps for the reasons I argued, perhaps for others. I didn't ask the jurors. But in that case, I was concerned that it was so high profile, my client wouldn't get a fair trial. There was a plaque near the courthouse honoring the man. A segment of an interstate highway in Connecticut had been named after him. There's just lots of publicity about the case. At sentencing, for example, 70 uniformed officers marched down the street with his widow dressed, I think, in red, and there were pictures in the newspaper. So, everybody knew I thought about the case. We went to pick the juror. A lot of people didn't know, but those who did know anything about it, the question became, could they put aside what they knew and decide the case solely on the evidence in the courtroom? And if they answered yes, they were selected. Now we get to the question of the juror in the Trump case, who lived or who spent the night one night in one of the lawyers' homes involved in the case. To me, if I'm the judge, I eliminate that person immediately. If you're a guest in my home, presumably you trust me. You trust me enough to close your eyes and go to sleep without clutching your wallet. And you wouldn't do that with just anyone. And so that lawyer is going to get up and make is going to make argument to the jury. And my view is that lawyer is going to be more trustworthy to a juror than others, because that juror has been a guest in that lawyer's home or that side of the aisle. So, I just...
What I've got on the screen here, the Washington Post reports this from one of the jurors that was going to be seated, but came in, I think, on day 2, and said, quote, "Yesterday alone, I had friends, colleagues, and family push things to my phone regarding questioning my identity as a juror," the woman said after being called into court to speak to the judge and the attorneys. Quote, "I don't believe at this point that I can be fair and unbiased and let the outside influences not affect my decision-making in the courtroom." In other words, there was a juror who, based on media reports, was identified by members of their own family and friends as, "Hey, it looks like you're one of the jurors." And because of that, Norm, this juror didn't think that they would be able to honor what was required of that position because of the negative consequences of doing something other than what the public there locally expects them to do, and because they have been reasonably identified by our very trustworthy media.
Well, very trustworthy. I note the sarcasm. But that's a reason to get rid of a juror, and it's a reason to question, just how you're going to seat a jury.
Here's the question, and I want to nod to Jackson Barrett over on Rumble. Jackson, you take the position that a change of venue should be almost automatically granted. But my question, Norm, is procedurally, when would a motion for a change of venue be proper? And what is the legal standard that one would necessarily need to meet? And can we fairly square a successful motion? Not that Judge Juan Merchan would let this thing go at this point, right? But aside from that, is that fertile ground?
No, it's not. Motions for change of venue almost routinely fail. The classic way to do so is to hire some media studies company to do polling in the community and to show that 90% of people have a strong view one way or the other about the case or an issue in it, and then present that to the court. I can't think of a case in Connecticut, and there may be one that it's nagging at me, where a change of venue motion was granted. If you look at the Enron case and in the case of Jeff Skilling, there was no change of venue motion granted. In spite of the devastation that the Enron collapse caused to people in the Houston area, I think that Sotomayor, might have granted, if memory serves, and I didn't look at the case beforehand, and sorry about that, folks, but if memory serves, I think Sotomayor suggested she might have granted a change of venue. But change of venue is almost impossible. And in this case, well, in cases where I've made it, as in the Dingwall case mentioned earlier ago, the felony murder in cases where I've made such a motion, the court always says, let's see what happens during voir dire. And, I think in order to get a change of venue, you'd have to go through a lengthy voir dire process and not be able to find people that could satisfy the court they could be fair and impartial. And, that didn't happen here. Candidly, in 3 days of jury selection, they got 13 people. The defense has used all of its peremptory challenges, and some people, including a dear friend of mine, Jim Nugent in Connecticut, say it's preemptory. No, it's peremptory. Let's get that right. But a peremptory challenge is a challenge that a lawyer can use to get rid of a juror, because in the lawyer's judgment, that juror can't be fair and impartial. And so New York has, I don't know how many, a dire voir dire or a dire voir dire. The Trump team has used all its peremptories. They've sat 13 people, and that argues against the need for a change of venue, because in fact, a fair cross-section of the community has yielded a jury that, at least in Judge Merchan's opinion, is capable of being fair and impartial. And presumably Trump's team has accepted some of these jurors before they use their voir dire, before they use their peremptories rather. And so I just don't see, I don't see a change of venue motion successful. Oh, here you go. Thank you, severe conservative. That's the case I was thinking about. The Adrian Peeler case in Bridgeport was moved to Waterbury. The Peeler case was particularly tragic, involving the death of a mother and her child, as in retaliation for their potential as the mom's witness in a drug case. And so, that outraged the community. But candidly, I don't remember. I don't know if you remember, severe conservative. Did this happen prior to jury selection? Did it happen during jury selection? Because I believe that Trump's notoriety was at least as great as the Peeler notoriety in the Bridgeport case. So, change of venue, people are still kicking that idea around in the Proud Boys case, on the case, or the J6 cases. I'm being encouraged to consider filing one. There's a group working on a motion. It's asking me to file one in a J6 case that I have, where there was a superseding indictment just last night, or just yesterday afternoon, I should say, not last night. And, I'll file it to make the point and to preserve the issue. But change of venue almost never happens. So.
Yeah, practically, this is a state law issue, right? So I wonder where this would be shifted to, that would not have the same effect. And that's not to catalog the whole of the state of New York as being as blue as Manhattan tends to be, or as anti-Trump, maybe that's more precise, as Manhattan tends to be. But this trial does require a lot of infrastructure because of the parties involved, right? So if we're getting out of the infrastructure of Manhattan and somewhere that may be a more neutral ground in terms of jury, available jury pool, there's still the issue of whether that the courts locally would be able to handle such a spectacle, right?
Yeah, well, there is that. I want to give a shout out to Trump's attorney in this case, Todd Blanche. He's doing a spectacular job of keeping his wits about him in this difficult case. I know that high profile cases are a unique challenge to lawyers. You've got a lot of internal pressure to excel, obviously, to represent your client to the best of your ability, and then the enormous, I don't, unless you've done it, I don't know that I can convey it accurate or adequately, the enormous pressure that comes of the worldwide attention in the case. And I've not had Donald Trump as a client. The Proud Boys, yeah, I got a lot of attention. Alex Jones, it's close, but no cigar, maybe a cigarello. And then the Fotis Dulos case, maybe another cigarello. I think Blanche is doing a spectacular job, and I give him a lot of credit.
Yeah, I think I asked you this morning, is there anybody talking about, and I'm thinking about my relationship with my clients and those that I shepherd through litigation, albeit almost exclusively on the civil side of things. But trial and litigation is extraordinarily emotionally taxing, right? We talk a lot here about the time and the cost and the burden of litigation, Norm, especially in the criminal context, what's at stake. But I'm constantly, I feel like during my quieter moments, thinking about what an amazing moment and time to watch our justice system uh, prosecute a man like Trump in so many different ways at the exact same time in an election year. And I wonder to myself, does anybody take stock of what caliber it takes, what caliber type of person it takes to be able to continue on, just to continue on? I'm not talking about success or failure. I'm speaking specifically about the sort of stability and discipline that it requires of someone like Trump to withstand that times 5, right?
Yeah, I can't. To me, it is unfathomable. He is a
Same,
larger
same.
life figure.
And there's a lot to be said for that. Despite what one might feel about Donald Trump, if those if every attorney was honest with themselves, if they were to put themselves in his shoes and to be responsible for the for hiring competent counsel, for running a campaign, and for maintaining an air of stability and calm to his 75 plus million voter base is like you said, Norm, it's extraordinary. It's beyond my ability to capture here in words.
No, and mine too. And the case just frankly stuns me. I mean, let's shift. We'll go a little bit out of the order we talked about this morning and talk about the Florida litigation as an example of the kind of pressure that Trump is under. As everyone knows, he stands accused in federal court in Florida of 32 counts of violating the Espionage Act for having in his personal possession after his presidency classified information that could adversely affect the interests of the United States. And Jack Smith, who's been named one of the most 100 most influential people in the United States by Time Magazine, is prosecuting him. And there is a May 9th deadline in the Florida case for Trump and his lawyers, and I gather Todd Blanche is in that case as well.
That's exactly. I think that's the basis for the Sixth Amendment issue that we'll.
Right, and we'll talk about that just right now. There's there is a May 9th deadline for them to identify what documents they're going to use in their defense. I mean, first, I would resist that if I were Blanche, and I'd probably lose. But here's the bottom line.
And I believe they have, just to clear, I think they have been resisting that pretty strenuously. And I think that at the point that it mattered, the May 9th deadline was set.
So the critical issue is who has the burden of proof in a criminal case? The government. The defendant need do nothing at all. Jurors are told in many courts and many jurisdictions that the presumption of innocence alone is sufficient to convict if you believe the government has not proven each element of the offense beyond a reasonable doubt. And so I always resist any pretrial disclosures on the grounds that while I may think I know what the government's going to produce, until I see it admissible in a courtroom, I don't know how I'm going to react to it. And why should I give the government the time of day? Why should they know anything that I have up my sleeve? Because it's their burden of proof and their burden of persuasion. They have to prove their case beyond a reasonable doubt, the presumption of innocence, blah, 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 blah. Courts will require you to provide advance notice. And in the Florida case, Judge Cannon has said, okay, produce these exhibits. Well, here's the problem. In order to produce the exhibits, Trump and his lawyers have to review them and discuss them in a SCIF, and that is a secure, compartmentalized, whatever, I can't remember the acronym for SCIF, but in a room that can't be eavesdropped upon. Well, where are Trump and his lawyers right now? They're in Manhattan. Where have they been for the last few weeks? Preparing for the Manhattan trial. And so how can Trump prepare for two trials at once? He can't. Well, maybe he can, but how can the same lawyer do so? I don't know.
Yeah. And so just to make unpack that a little bit. So you said SCIF SCIF. I think that may be sensitive or classified information facility, something like that. Anyway,
facility. I think. Yeah.
And what we're talking about here is in the classified documents case, Trump is obligated to disclose a mountain of information that he intends to introduce that needs to be addressed by the court, right? There's going to be some sort of adjudication of whether his considering certain things to be personal records or whatever else declassified, but that there's going to be a determination made on a case-by-case basis with these documents. But certainly these things can't just be done in a normal course of business, as it were, right? And therefore there are certain facilities that will house these sorts of analyses, right? Where information that is sensitive can be unpacked, at least to some degree of enhanced security. So therein lies the intersection between the tension of the Manhattan trial and the overwhelming demand that is now in an acute way cresting for Trump in the classified documents trial. And so the issue of a Sixth Amendment right to counsel is what, Norm?
So the Sixth Amendment gives people certain rights, and let's focus on those, what the Sixth Amendment does. The Sixth Amendment gives a defendant a right to a speedy and public trial. It is a personal right that belongs to the accused. The Sixth Amendment, as interpreted by our court, gives a defendant a right to his or her counsel of choice. And I'm emphasizing the word defendant, the words defendant and accused here, because the Sixth Amendment is a fair trial, speedy trial, public trial, right to counsel of choice that attaches to the individual accused. The government has no Sixth Amendment rights, period. Read the amendment. The fair trial responsibilities that a trial judge has with respect to the government arise from the Due Process Clause, in this case of the Fifth Amendment. Where the parties have a right to, and the court's inherent supervisory authority to see that justice is done. In other words, a judge's responsibility is to obviously call balls and strikes, and to do so with an aim toward, assuring that justice is done. That is not a constitutional right. Well, it's insofar as it's a due process right, it's constitutional. But all due process really talks about is notice and an opportunity to be heard. And even there, the government cannot deprive a person of life, or liberty, or property without adequate notice. And so you could argue that the Due Process Clause doesn't even give the government any rights. And so the inherent supervisory authority to give the government a fair trial may not be a constitutional right at all. And if that's the case, then Jack Smith is full of it. Jack Smith is full of it. He has filed a motion basically saying that he needs that the public interest is being frustrated because the public has an interest in a speedy and fair verdict, given the unique national importance of this case, and therefore there should be no delay. I mean, Jack, what's the rush? Take a look at the docket in any federal courthouse in the United States, and what you'll see are people who've lingered sometimes for a year or more awaiting trial.
Yeah, 100%, Norm. So another hat tip to two people here. Number one, the esteemed A.R. Hoffman over at the New York Sun for writing very, very precise and informative articles. If you have questions about or just want additional details about what Norm and I talk about sometimes with these procedural constitutional issues or the foundations thereof, I can find no one that writes on this stuff better and more concisely than A.R. Hoffman. So
that's really true. I mean, we are huge fans of A.R. Hoffman. I think he's a Stanford American History PhD and a Harvard JD,
yes.
who has decided to take his superior insight into our nation's history and legal foundation to the public in the form of AR, in the form of the New York Sun and his writing.
It's amazing.
It's and amazing. There's none better in the United States right now. I think he's Pulitzer Prize worthy.
Yeah, top tier stuff. The other hat tip here is again to Todd Blanche, Trump's attorney, because he makes the argument, Norm, and I'll just read from AR's article here. Mr. Trump's attorneys plant their client's flag on the argument that the special counsel, quote, makes no effort to actually identify how the government would be prejudiced by an extension of time to allow President Trump and his counsel the right to defend him in New York and before this court. The right to a speedy and public trial, like the assistance of counsel, belongs to the accused and not the government. And what apparently Jalapeno Jack has been saying, that, you know, he essentially isn't sympathetic to Trump's argument here because he elected to engage counsel to work on 2 cases, and that's not Jack Smith's fault.
No, that's right. And Jack can't have it both ways. I mean, you know, this is where, you know, I'm not a big fan. And I know some of our regular listeners are. I don't know if Dawn's here this morning because I'm expecting Dawn. I'm expecting a pickleball slap from Dawn McNeil any moment now. I'm not a big fan of claiming that these are political cases, meaning that they're driven by a political agenda. But when you look at Jack Smith's arguments and conduct in this case, what other conclusion can you draw? You know, Trump has these Sixth Amendment rights. He has a right to counsel of choice. He's chosen one man. He can't do 2 trials at once. The same lawyer arguably can't do trial preparation for 2 cases of this magnitude at once, unless he or she has a large staff and he delegates much of it, as it happens in most firms. It happens in my firm. I don't have a large staff, but I have associates, and their job is to help prepare files under my supervision. And, you know, it may be that that's satisfactory to Trump. Maybe it's not. That's a relationship between Trump and Blanche. And it may be that Trump has manipulated his counsel of choice decisions to affect the manner in which his cases can be tried, with an eye toward
maybe he is
in the general election in 2024. That's his right.
Well, but also maybe he is a satisfied customer of Blanche and that team. Maybe he has, in an amount, because we've criticized certain aspects of various defenses over the last year, because all of these cases began roughly around the same time with successive deadlines for filings and blah, blah, blah. And he had to quickly engage local counsel. He had to quickly, you know, respond with, you know, these preliminary motions, affirmative defenses, the answer in lieu of those kind of things. And that requires a quick but broad expenditure of cash and capital to have people that are reasonably competent to actually do this. Now that the cases are in motion, perhaps it's Trump that has found a team of lawyers that he's really comfortable with, and he actually sees that more value out of using them across multiple of these cases. These attorneys have also assessed that they are capable of competently doing that, number one, but also don't have conflicts that will emerge therefrom either. And that's a great marriage. I mean, there is a business at the foundation of all of this, right? These attorneys aren't working pro bono, and it is his right to go back to, he's an involuntary power user of law firms at this point. He's spending millions and millions and millions and millions of dollars on legal fees. I think in excess of 25 million last year alone, Norm, if you can believe that.
I think it was 22 million, but I'm not going to argue a million here, a million here. It's real money.
So it just, maybe he's finally sort of happened upon a sort of chemistry, a rhythm with these attorneys that he really likes, and he's going to stick to that. I don't blame him a bit. So
I'm looking at the comments. N1ROL Anonymous, not a fan of calling these political trials. What the fart is it then? Most of these cases are using novel legal theory, time to interfere in the election, and are exclusively the domain of leftists. You know, there is a body of law called selective prosecution, and it may be that it's time to develop another, or it may be, candidly, that should be circumstances in which jury nullification should be made available to jurors. I mean, in general, it's a prohibited doctrine. The theory is prosecutors are presented with facts. They evaluate those facts to decide whether, in their view, the law has been violated, and then they bring a prosecution.
Well, and then just to address the question directly, I think that there are plenty of outlets, plenty of platforms, plenty of shows and content that will feed the answer that you want with that question. And that's, with all due respect to you in one R0L anonymous. But what we do here is not exactly, we're not here to just feed your bias, to the extent we can. There is a lot of value in people understanding how these things are supposed to unfold. And oftentimes, if when we all sit with ourselves in the quietest moments and we are, we indulge honest self-disclosure, if you can say that you're not fundamentally sure of what's happening in a given case, then it's incumbent upon you to learn a little bit more. Our goal here is to empower our viewers and listeners. And yes, of course, I will make conclusions that Norm won't leap to, and vice versa, right? But in this instance, how do we distinguish ourselves for you as a viewer? What value do we bring by confirming your pre-existing biases and conclusions, right? That's anyway. That's all I'll say on that.
Well, I mean, that's a good point, because the goal of this broadcast is to discuss critically our evolving sense of a common conception of right in a republic. And in our republic, disputes are resolved as a matter of law. And Mike and I obviously are lawyers and have experience in the law in one form or another. And so what we try to do is spot issues where there's a disagreement in public about a legal issue and provide both sides of it, with an effort to promoting a discussion that might be bipartisan, where people can reach across the aisle. Because my fear is the republic's coming apart at the seams, and I want to save it if we can. And these discussions are designed to promote that. I guess we'll just jump into a new something or other.
And we're basically out of time here, but I at least wanted to mention this, and maybe we pick this up on Monday, Norm. I'm sure more news will kind of will come out today and perhaps over the weekend. But this is happening very close to me here in North Carolina, in the Piedmont, Central Davidson High School.
Wait a minute. Let's stop. And our anonymous, we're not calling you a bias hack. Not at all. We're just urging you to take a critical perspective on your own views and ours. And I'm so sorry if we said anything that offended you or made you feel that we were minimizing your contribution.
Look, we're not, and more directly, don't be so sensitive about it. You're coming here saying that, this is all, what's the point of talking about it if that's the case? Then if we take your position to the logical extreme, what is the point of us doing this? You don't have to be here. You don't have to get up at 8 a.m. and join us. It's your decision. No one's calling you a biased hack, but I'm certainly not going to sit here and let you say that that's an objective observance. Maybe, but you're saying it. And also, you can go other places to find places to tell you that everything is unfair, that everything's being cheated, that these are all politically motivated. That's not, there's nothing innovative there, right? And that's against the backdrop of knowing that, yes, there's a lot of evidence that we can point to that would inform. And I've actually said on this stream how many times, Norm, that I do believe that these are politically motivated prosecutions. That doesn't absolve us of the obligation that we have here to you to unpack the procedural issues and the timelines affecting the cases. Okay, so that's it. Illegal alien is now racist, Norm. You probably already knew this.
Yeah.
I knew this, right? But a 16-year-old apparently was suspended for 3 days at a Central Davidson High School for asking the teacher a question about an assignment, right? Saying that, do something with a vocabulary word, something to do with an alien. And allegedly he asked, what kind of alien, outer space alien or an illegal alien, right? And then, of course, this prompted another kid in there to want to fight him. Administrators were called, blah, blah. Then this kid gets suspended for 3 days. According to the articles, Eugene Volokh covered this in the Volokh conspiracy. This is from the Carolina Journal. There, may be counsel already involved. They're working with the system there. I'm really interested in this case from a First Amendment perspective, but I also think that this is more of a litmus test for stuff, beyond the Trump the Trump spectacle in those trials. This is the real world stuff. Like I said, this is very close to where I am in the Piedmont of North Carolina. This is, Davidson County. You can look that up on a map. So maybe we track this, Norm, but certainly talk about it in more detail on Monday.
Yeah, I mean, and those of you who want to read ahead to participate in the discussion, take a look at Tinker versus Des Moines. Tinker, Tinker versus Des Moines, a 1969 United States Supreme Court case. This in the height of the Vietnam era protests. A young man, I think it was a man, wore a black armband to school, and this outraged some of his or her classmates and the administrators. He was banned from doing so, and he sought on First Amendment grounds to vindicate his right to wear the armband, and the court held he could. You don't shed your constitutional rights at the courthouse door. That you only that an administration can only monitor and enforce regulations as to conduct when they substantially disrupt the educational program. And it seems to me that in the case that as I understand it, in North Carolina, the person who really needed to be disciplined was the kid who, when the kid said illegal aliens, threatened to fight him in class. That's almost a criminal complaint. So how is it that the person who engaged in violence or a threat of violence in response to speech got a pass, and the kid who engaged in what is arguably protected speech got suspended? It's like it's a transvaluation of values, you who read Friedrich Nietzsche might say, and it's bizarre,
Yeah, it's troubling. Like I said, I'm interested in this. I've had another one of our mutual colleagues reach out to me to see if, there was anything to do to get in touch with the family. Like I said, I understand that, based on the reporting from various sources that they are in touch with an attorney, but, we'll keep everybody updated on that. I certainly want to make sure that, and this is funny, the libs of TikTok covered this. Elon Musk is aware of this case. So, there's a lot of spotlight that's going to be, applied to this. And it may be that this actually goes nowhere, that the school district has to make a very public comment and back up, or they could entrench themselves and fight a losing battle. This is a more rural area of North Carolina, and it is more heavily conservative. And to that end, and I think it's interesting that a 16-year-old, right, is involved in something like this. I think this is a positive sign, in my opinion, that younger people are not being led to slaughter like we feared they may be. If young people are willing to put themselves out here, and this guy's not even old enough to competently sign a contract under the law, right? So this is a product of his rearing, right?
So I want to comment on Phyllis Druin's comment. Norm. The kid that wanted to fight was an illegal. He has more rights than God. I understand the form of what you said, Phyllis, but I don't know first that the kid wasn't illegal.
I don't. That would be news to me.
He may not have been. I don't know what it is. It's certainly a nice rhetorical thrust to say that someone has more rights than God. But Phyllis, much though we love you, that's sort of meaningless in this context. And walk the rhetoric back a little bit and try to get your facts straight. And if you have information, and I'm not trying to insult you, Phyllis, I'm really trying to have a discussion. Do you know that the kid wasn't illegal? Because if he was, that's really interesting.
It's landscape shifting for this case specifically, because then the school district has a lot more to consider in the way that they respond to this. Apparently, you can't appeal a suspension that's less than 10 days under the district policy. So they're trying to hide behind that. But I think the parents are motivated to seek some sort of recompense for this. I don't know what form that recompense will be. I'm not speaking specifically about cash, but it's troubling that, we've got people staffing schools, public schools right now that are not encouraged to have a backbone. I think there are a lot of ways that this issue could have been dealt with in the classroom and at the school level that shouldn't have made this blow up. And the fact is, in this context, that it was not handled and put out. Right. So something is amiss there. That's not news. We know that. But something is really amiss that this issue rose to this level of prominence and this kid was suspended. So we'll stay on.
So Phyllis raises the point that, that the young man who threatened to fight is of Spanish origin. he may or may not be illegal. I don't want to drive too fine a point on it. I take your point, Phyllis, that he undoubtedly felt aggrieved by the comment because he or his loved ones may be here unlawfully. And that is the central issue here, because, I know Jackson Barrett is a real big
and that would be interesting, right? That would be fascinating if this, so just to point out, Anonymous says local chatter isn't illegal. Phyllis says it's reported that he was of Spanish origin. Again, the quote that we have is that he said, illegal alien. And then the justification that we have via these articles is that, there was no reference to any ethnicity, country of origin, that, the reference to an illegal alien is a reference broadly to people that don't come here via, lawful ports of entry, green card visas, etc. But, and then let's see here. Severe Conservative wants a link. I'll drop one in for you. It's on Reason as well as the Carolina Journal, but I'll throw some in here. But I do think that there's more context if the young man is aware that this other student is here as a product of unlawful entry and makes that statement in the middle of class, it might rise to the level of intentional disruption of a school environment as per a school policy. I don't want to take a position, haven't confirmed this, so it's local chatter. But if that is indeed a fact that comes to light, that the student that reacted emotionally and encouraged, solicited a fight with this guy is actually a non-citizen, right? An illegal alien, then this is North Carolina is going to blow up here in a second. But we are the center of the known universe, Norm. You knew this.
Well, I mean, to me, how a collection of people acquire a sense of identity, what terms they use, how they recognize and define themselves against others is a significant issue. And so we have, population migration, a significant migration across the southern border right now, and many people feeling threatened that traditional notions of identity in the United States are being erased, and those people are referred to as white supremacists and so forth. And then we have an arriving class of people with customs, mores, and affectional bonds of their own, who are coming in without authorization and establishing a life that we tolerate, sometimes for economic reasons. And they're here, they're not going anywhere. We're not apparently forcing them out. We may not be able to force them out. And they have a right or at least an expectation to have affectional bonds of their own. The conflict between those who feel they're here, if not as a matter of right, but certainly as a matter of fact, and are inspired by nothing other than a desire to survive, that's a real thing. And the fact that some people are here and feel threatened and believe that their status as legal gives them superior rights or interests or whatever to those who aren't, that's a real thing. How we resolve these conflicts is also a real thing.
Yeah, the fact that an educator would feel as though he or she needs to favor someone of that status over someone asking or saying a question like this is also a real thing, right?
Yeah, I hear you. So it's a troubling. I mean, we've touched on 3 cases today that go somewhere, and I don't know where. The comments to those of you who are critical of us, I get it. Thank you. We're listening. We're trying to evolve a set of concepts that help explain the complex reality that we live. And I get the impression sometimes that we're pouring new water or new wine into old skins, and the skins that have held us together in the form of traditional constitutional norms need to break, and we need to form new norms under the rule of law. That's what makes constitutional litigation so high stakes. And what we're discussing here are ground level events that will likely find their way into the high courts, if not in these cases, in cases like them in years to come.
Yeah, Ian, you're making great points. Again, this goes to the state of mind of the suspended student, right? And then the context of how the remarks were delivered. We don't have any of the information, but these are all questions that I had internally as well. And, similar to the issue of policing, racism in policing, what incentive structure exists in 2024 for law enforcement officers to act in an outwardly and observably racist way against one group of people compared to another? It just doesn't make any sense. in this context, I think the question sort of reverses itself. And so it is a credible question, I think, for the 16-year-old. Would his teacher be reasonably calculated to be giving him an assignment that includes some analysis of the word alien in the context of illegal alien? And so is it even can we infer some intent or state of mind because of that? I think, again, that's going to be in favor of the administration and of the school district. They'll have to overcome that. But I still don't think that it's persuasive enough or substantive enough to have validated what happened here in terms of the suspension. So anyway, Norm, what else? Anything?
We talked our way past the deadline, but the cases were compelling and we didn't want to wait till Monday because who knows what will happen by Monday. So folks, thanks for listening in. Spread the word. Mike, how do people find us and how can they support us?
You can like this stream and you can subscribe. You can share Law Pod Daily. We're on YouTube, we're on X, and we are on Rumble at Law and Legitimacy. We are here 8 a.m. Eastern Time, Monday through Friday, except on days where Mike wakes up at 7:11 and texts Norm 35 seconds later to say, hey, we got to bag it. Anyway, we are also on Spotify, Apple Podcasts, Overcast, Audible, wherever you find premium podcasts. The audio-only versions are uploaded daily. So you can go over there, give us 5 stars and a nice comment. Otherwise, you can find me, just surreally out here, as we say.
AMF, yo-yo.
AMF, yo-yo. See everybody.